either, but thank you. Mr. McDaniel, who do you want to call next?
Just write down the list, Your Honor. It's fine with me.
All right, let's go with Andrea Lewis. Jones, can you confirm for me that everyone had an opportunity to watch the video regarding their first appearance rights?
Yes, Your Honor, they have.
Thank you so much. Miss Lewis, good morning.
Hello.
Miss Lewis, tell me your full name for the record.
Andrea Anna Garcias. Lewis Sanders.
All right. Miss Andrea Lewis, Miss Lewis, did you understand the rights that were explained to you on the first appearance video?
I actually have been told something about what they are charging me with.
Hang on.
All right. So Miss Lewis, hold on.
Let him utilize that mute button.
Your question, lady.
Could you repeat the question, Your Honor?
Sure. Miss Lewis, let me just tell you this. You have the right to know why you are in jail. You are presently in jail because you allegedly failed to appear to my court in case number 23 CF 37. I ordered that you be held without bond for that alleged failure to appear. Ma'am, you are also in jail. I do not need to hear back from you. I am telling you why you are in jail. That this is not your opportunity to speak. Miss Lewis, you are also being held in custody because you have a writ of bodily attachment from Leon County in Leon County case number 17 DR 2468. That writ of bodily attachment indicates that you may be released on a purge of $1,000 cash, or you will be required to serve a 90-day jail sentence. So that's the reason that you're here. Ms. Lewis, you have the right to remain silent during these proceedings. If you choose not to exercise that right to remain silent, do not interrupt me, Ms. Lewis.
I'm not the person you think. You are putting a charge on me that's supposed to be on somebody else. So
Okay,
yes, I
Ms.
do
Lewis,
have the right to.
if you say anything
but I'm telling
during
you
this
that the charge is
proceeding,
not supposed to be
all right.
on me. It's supposed
Mr.
to be on somebody
McDaniel,
else.
let's have her leave the room. We will handle a first appearance tomorrow. There is to be no action. She may not.
No, it's not no first appearance. Just leave it how it is.
Thank you, Mr. McDaniel.
Yes, Your Honor.
Willie Monroe.
And get out of my chair.
The purge is 1,000,
Willie.
but she needs to be first appeared tomorrow. John, Mr. McDaniel, would you like a life management evaluation?
I will ask him to. And she's had some mental issues, Your Honor, so I apologize.
Sure.
And I don't know if it'll be any different tomorrow. I mean, it's, I tried to talk to her this
Sure.
morning and she's, come on up here, Willie.
In the interim, why don't we go ahead and have an eval and see if there's any way we can try to stabilize her, okay?
Will do.
Sure. Mr. Monroe, come on up. Mr. Monroe, good morning.
Good morning.
Mr. Monroe, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am, I did.
All right. Mr. Monroe was taken into custody yesterday after Jackson County Domestic Violence Court, and so that was in my courtroom. Mr. Monroe, you are being held for allegedly failing to appear in court in Judge Mercer's case number 24MM615. Mr. Monroe, you will be held until you answer to Judge Mercer on those charges. However, I understand that Judge Mercer has also revoked your bond in some of your CF charges. Counsels, can you bring me up to speed?
Yes, Your Honor. He revoked his bond on Monday, and then my assistant sent in an order the same day. I believe it's been received. It just hasn't officially been entered yet for those
It may be that Judge Mercer doesn't even know the order is there. Give me 1 second. Because it goes to a general queue and he may not know it's there. I will send it to him because I'm the one who checks that general queue, and I have not had an opportunity to review the orders from this week at all.
Yes, the order was sent in on Tuesday.
On Tuesday. So yes,
Yes.
day before yesterday.
Do you need those case numbers or you?
No, just give me 1 second. I'm pulling up the work queue and I'll send them to Judge Mercer. Mr. Monroe, do you understand why you're here?
No, ma'am, actually don't, because Judge Mercer's, I was supposed to come to court until the 17th of December.
John, have you looked into that or understand what's going on there?
Your Honor, he had another case, misdemeanor case that was dismissed. And when they dismissed that case, they filed this, another misdemeanor case, essentially the same kind of case. And he was sent notice to be in court on this particular day on December 2nd. And he did not appear for that court date. I mean, he may have got confused, I don't know, but the Judge Mercer did give him a bond. It's a $2,500 bond on the misdemeanor case. But he has the felony cases that are ongoing, and due to the allegations occurred after the felony cases, he went ahead and revoked his bond, his felony bonds, or for you to make a decision on that later.
Sure.
Can I say
So
something?
would there be any benefit? So Mr. Monroe, here's the deal. I'm not making any changes today to what Judge Mercer has already ordered. Okay. That said, I recognize that you were supposed to be in court yesterday and you came to court. So I am happy for you, if your attorney thinks this is a good idea, to explain to Judge Mercer if you think you may have gotten the dates confused, because I will note that you were in fact in court yesterday. Okay. That said, and Mr. McDaniel, for everyone's information, when the alleged victim who is Lily Monroe, the alleged victim on the
Yes,
new
Your Honor.
cases, Lily Monroe filed a petition for injunction for protection. She has filed 3 in 2024. She did not show up one time in court. She showed up 30 minutes late yesterday, but so did Mr. Monroe, quite frankly. There was no temporary order in place at the time. There was one injunction that was issued, and then she filed a request to revoke the injunction. Yesterday, when I asked whether or not she wanted to proceed with the injunction and provide testimony, she said she did not wish to proceed with the injunction and provide testimony. That said, I understand that civil injunction proceedings, the petitioner is in fact the petitioner, whereas in criminal proceedings, the petitioner is the state of Florida. But I am making both the state and the defense aware of issues there, okay? And I have no issues with, if Mr. McDaniel, you wish to have Mr. Monroe come back before Judge Mercer, so that, number one, Judge Mercer knows that Mr. Monroe was in court yesterday for DV court. And if you think that it makes a difference for you to give an explanation about any kind of confusion, I'm happy to ask him to come back.
I don't think it's going to matter, Your Honor, because I think the state's intention was essentially, and that's what they told me. Now, Jake, don't correct me if I'm wrong, but they filed it for the primary intention to revoke his bond in the felony case. The last one just got dismissed 2 weeks ago, so I don't think that they know she's not to cooperate. And, I think that was their intention, was to revoke his bond because of, correct me if I'm wrong, Jake.
The previous case that you're referring to, was 24347 MM. That one was dismissed, I think, if I remember, when was it? October 9th. And I filed on the new case. Let me see when it was.
It was
On
15
October
days after.
24th. Yeah. So, and the state intends to proceed on this new case right here. And I guess as it pertains to the misdemeanor, the only request we would make is that, no contact with the victim be enforced as a condition.
Well, I'm not giving any kind of release. Judge Mercer,
No.
well, he did set a $2,500 bond. So Judge Mercer set a $2,500 bond, no contact with the victim if you make that bond, Mr. Monroe. But you've got no bonds on your felony cases. Judge Mercer has issued no bonds there. And if the state is indicating, you are telling me you have an independent witness
Yes.
and the independent witness is cooperative?
For what we know, yes.
All right. So if that changes, Mr. McDaniel or Mr. Monroe, I wish for you to communicate that to your public defender in felony court. Okay. And I will certainly consider it if the state can't prove the case, making a change on the hold without bond. Okay. All right. Thank you, Mr. Monroe. All right, next is going to be Ariel Swearington. Ms. Swearington, good morning.
Good morning.
Ms. Swearington, tell me your full name for the record.
Ariel Swearington.
Ms. Swearington, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Ms. Swearington, you are being held for allegedly violating the terms of your state probation in Jackson County case numbers 21 CF 635 and 24 CF 66. I've ordered that you be held without bond until you answer to those charges. I'm going to appoint the Office of the Public Defender to represent you on that violation of probation. And Mr. Guy Green will be out to see you. It is likely that you will make the December 17th VOP docket, and we'll see you on that date. Mr. McDaniel, on her behalf, with that appointment, what say you?
Your Honor, we're going to enter plea of not guilty and just ask to set it on that court date, December 17th.
All right, fair enough. That's what we'll do. Ms. Swearington, we'll see you then. Sabrina Allen. Ms. Allen, good morning.
Good morning, Judge.
Ms. Allen, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Ms. Allen, you are being held for allegedly violating the terms of your state probation in Jackson County case number 20 CF 643. The basis for the violation is our alleged new law charges that I believe come out of Liberty County. I've ordered that you be held without bond in Jackson County pending resolution of your violation of state probation. The court orders or will appoint the Office of the Public Defender to represent you on this violation. Mr. Guy Green will be out to see you. Mr. McDaniel, as to that appointment, what say you?
Your Honor, I'm going to enter plea of not guilty and just ask to set it on December 17th pretrial docket.
Now, are there charges that we need to advise of in Liberty County? Dawn?
Well,
Or is it, are
Liberty
you
County
wanting to
had
say something?
Liberty County
Sorry.
transported her over here. They didn't want to keep her or the previous Miss Swearington over in Liberty County Jail, so they transported her over here. I assume they kept a detainer on the case. So when the case is over, she's going to go back to Liberty. There is a bond in Liberty of $1,500. So, I mean, if she does happen to get released on some kind of option, she can bond out on the Liberty County case, or they'll transport her back over there.
All right, but she's certainly not being first appeared here today for this Liberty County case because she was already in custody there, correct?
Correct. Yes, Your Honor.
All right, Madam Clerk.
I'm showing that there are two cases here, violation of state probation. I'm just trying to find out if they concern both of them.
All right, let's take a look. So I see that there are two cases. It just simply didn't make the docket. The warrant is on the BOP warrant has both case numbers on there. So Ms. Allen, you're being held for allegedly violating the terms of your state probation in Jackson County case number 20 CF 643 and 20 CF 636. Okay.
Yes, ma'am.
All right. Does that clear that up?
Yes,
Okay,
Your Honor.
excellent. Ms. Allen, you will likely come back on December the 17th. Did you already deny the allegations in the VOSP on her behalf,
Yes, Your
Mr. McDaniel? Okay, fair
Yes,
enough.
Your Honor.
Thank you, Ms. Allen. I'll see you on December the 17th.
Yes, ma'am.
To let you know.
I'd like to call up Jasmine Lovett. Ms. Lovett, good morning.
Good morning,
Ms. Lovett, tell me your name for the record.
Jasmine Lovett.
Ms. Lovett, you are in custody for allegedly failing to appear to a case in Liberty County. It's case number 24 MM 51. Your attorney has provided the court with a copy of that capias. Let me tell you what I see, and I'm sure he's already talked to you about it. The underlying charge was possession of paraphernalia. Judge Bufano in that case has ordered that you be given a bond in the amount of $250, and that is cash or surety. Therefore, if you can make that bond, okay, then you need to make the bond and make sure you go to court whenever you are told in Liberty County. If you do not make the bond, Liberty County will come and get you, and you'll be able to answer to the charges there. Do you understand your options?
Yes, ma'am.
Okay, any questions?
With the bondsman, do I have to pay the whole $250 or would it be less than or?
Yeah, usually a bondsman will let you pay a portion, and sometimes it's 10%. But that is a contract between you and the bondsman. And you'll just have to reach out to the bondsman and see what they are willing to do in your situation.
Okay,
And Judge, if I can let her know, most
Sure.
bondsmen have a minimum fine fee of $100. So, you know, it might be cheaper to just pay the $250.
So you're saying that most bondsmen won't even do a bond for a charge to the client that's less than 100 is what you're saying?
Correct. Yeah, I mean, they're generally going to want at least $100 a bond amount. So
Sure. And if you decide to put the 250 up, if you show up in court every day that you're supposed to, then you get the 250 back, or it can go towards paying your court costs and whatnot. So that choice is yours, okay?
okay,
All right. Good luck to you, ma'am.
all right, thank you.
All right. William Stewart. Mr. Stewart, good morning.
Morning,
Mr. Stewart, tell me your full name for the record.
William Joseph Stewart.
Mr. Stewart, did you understand the rights that were explained to you on the first appearance video?
Yes,
All right, Mr. Stewart, you are being held for allegedly burglarizing a dwelling. That is a second-degree felony, punishable by up to 15 years in prison and/or a $5,000 fine. However, based on the allegations, this could be a life felony, as it could be a burglary with a battery. You're also charged with 1 count of lewd or lascivious molestation. That is also a second-degree felony, punishable by up to 15 years in prison. I do find there is sufficient probable cause for both of the charges. Mr. Stewart, it's my understanding that you have no prior criminal history. Is that correct?
yes, that is correct.
All right. Mr. Mitchell, on behalf of the state, what information do you have regarding this case? Is there any evidence that there was any not relationship, but communications or anything between the victim and the defendant in advance?
Nothing at the moment.
Do you have anything other than what's in the complaint?
We just have the complaint for right now.
And am I to understand that based on what's in the complaint, that this was a complete unknown individual to this alleged victim?
With what we have now, yes.
Mr. McDaniel, you certainly don't have to, but that makes a difference to what my release options will be for this individual. And I am happy to consider anything that you wish to place on the record.
Your Honor, at this point in time, I don't have anything. So we just asked the court to set a bond, and I assume a federal, when we get more information, we may ask for another bond hearing in the future.
All right, fair enough. All right, Mr. Stewart, based on what I have read, I'm going to set your bond on the burglary in the amount of $250,000. That will be cash or surety. On the L&L, $250,000, total bond $500,000. If you make those bonds, you are to have no contact with anyone under the age of 18. You are also to have no contact with the victim or the victim's property. Do you have any questions for me are there any additional bond requirements requested?
I think you hit all of them.
All right. Anything further from the defense?
No, Your Honor.
All right, Mr. Stewart, and you will be brought back up to court for arraignment probably in January. Okay.
Okay,
All right. Thank you, sir. Does that take care of first appearances, guys, out at the jail?
Yes, Your Honor, that's everybody.
All right. Then that concludes first appearances at 8:54. Thank you,
Thank you, Your
guys.
Honor.